Hello and welcome to Module 4-E. In this module, we shall discuss the dispute resolution mechanisms under RA 6657. Now, this is the last sub-module for Module 4. And after this module, we shall officially be closing our discussions on agrarian reform law, the first part of our course. After this one, we shall have the midterm examinations, and after the midterm examinations, we shall proceed, as promised, to the other social pieces of social legislation according to our course outline. All right, and so this module, in this module, we shall be discussing the following key topics or key points. Firstly, in order to establish the point of discussing the dispute resolution mechanisms under RA 6657, we must first establish the existence of quasi-judicial powers under RA 6657. Now, this quasi-judicial power uh, is vested by law, vested by RA 6657 on identified government agency, government agencies for that matter. All right, and so after establishing the existence of quasi judicial powers under RA 6657, then we move on to the subject of the quasi judicial powers under RA 6657. Within the framework of RA 6657, this is called agrarian dispute. Okay, and in this main topic, in this next topic, we shall identify what groups of cases belong to agrarian dispute, to the broader term or notion of agrarian dispute. Right, and that preliminary discussion will enable us to have a systematic discussion of the procedure and judicial review of these groups of cases that belong to that broader term, broader concept of agrarian dispute. Right, but before we go to the specific procedure and judicial review rules for the groups of cases that belong to this agrarian dispute, we shall first be discussing the procedure, the applicable rules for when the agrarian dispute case or an agrarian dispute case ends up not in the government agencies within the framework of RA 6657, but rather in court. You know? uh, and because they end up in court, there has to be a procedure that would enable the case to be brought back in to the framework of RA 6657 and to the framework of the dispute resolution mechanisms under RA 6657. We shall learn that, therefore, in the key topic on agrarian disputes filed in court, the procedure. Right? And so, after that discussion, we are ready to move on into the specific procedure for the different groups, different types of cases that may belong to the broader term agrarian dispute. Okay, and as we shall learn later on, there are three major groups. First, tenurial arrangement controversies. Okay, just compensation controversies, and criminal violations under RA 6657. They are grouped into three, and they will be discussed separately because their procedure will vary depending on the group. All right, depending on the type of case that will fall, that may fall under the term agrarian dispute. Right? And so we proceed with the first key topic, quasi-judicial powers. Now, quasi-judicial powers uh, are vested under by RA 6657, specifically Section 50 of RA 6657, no, to a government agency which does not belong to the judiciary, to the judicial branch of the government. Rather, it belongs to the executive branch of the government. In this case, diba, the Department of Agrarian Reform. It's within the framework of the executive branch. Notwithstanding it belonging to the executive branch, it is given some sort of power that resembles the power granted to courts, no? That resembles judicial power. But it's not really a judicial power because the one exercising it is not a judge. The one exercising it does not belong to the judiciary. And so this phenomenon, this arrangement, uh, is rather named or called as quasi judicial powers. All right, it's the power to adjudicate. It's the power to resolve controversies, disputes, adjudicate on the rights and obligations of the parties, interpret the law and apply the law. Basically, just like judicial powers, the only difference here is that the one exercising the power, the one on whom the power is vested, is not a judge, is does not belong to the judiciary. Rather, he or she is an officer in the executive branch. That's why the powers granted to him or her are called not judicial powers but quasi judicial powers. Now, as it is elementary, it is very basic that this quasi judicial powers that's vested by law. All right. In this case, vested by RA 6657, specifically Section 50 thereof. Now, in Section 50, it says that the DAR has the power to adjudicate matters relating to agrarian reform. All right. But as we shall see later on, although the law uses the term DAR, within the framework of DAR, specific offices actually exercise the quasi judicial powers, which are rooted under Section 50 of RA 6657. Still within the framework of DAR, okay, but for purposes of of clarity in the functions, for purposes also of easy identification of these offices, there may be some addition to the name, addition to the name of such offices or officers who, under the framework of RA 6657, exercise this quasi judicial power. Okay? But of course, the grant of quasi judicial powers doesn't mean or does not turn the DAR into alternate courts. No? Turned, they are not converted into courts. They are not made subject of general jurisdiction. All right, they are not given general jurisdiction, just like, let's say, the regional trial court has general jurisdiction. In fact, the grant of quasi judicial powers uh, here under RA 6657 is limited in nature. Okay, it's limited, its bounds are clear, delineated, and the exercise of quasi-judicial powers should be within the bounds provided for by law. All right. Outside the bounds provided for by law, the officer or the office exercising the supposedly quasi judicial powers would not have any power, would not have any jurisdiction at all. No, specifically here, under Section 50 of RA 6657, delineated uh, uh, in some respects, no, the jurisdiction, such that some aspects, even though they are relevant to the implementation of agrarian reform, but they fall under other agencies' jurisdiction. For example, uh, agriculture. No? While agrarian reform and agriculture are somehow interrelated because the subject of agrarian reform is agricultural land, right? In matters relating specifically to agriculture, to the conduct of agriculture, to the rules and regulations pertaining to the conduct of agricultural activities, the DAR, the Department of Agrarian Reform, does not anymore have jurisdiction. This is the line, this is the bound uh, which the DAR cannot validly cross, right? And so the other side, the Department of Agriculture will have jurisdiction, right? And there are also matters with regard to the implementation of agrarian reform, specifically perhaps in the let's say in the allowance for conversion, perhaps in the allowance uh, for yes, reclassification and conversion, which may in some aspects fall under the jurisdiction of the DENR, of the Department of Environment and Natural Resources. Admittedly, lands are considered as natural resources. And so, if in some aspects, in some respects, with regard to the implementation of agrarian reform, although primarily it's the implementation of agrarian reform, but in some aspects which may fall under the jurisdiction of the DNR or the Department of Agriculture for that matter, the quasi judicial powers will no longer apply, right? And these bounds, okay, will serve as the limitation of the grant of powers. And as I've said, these bounds will have to be respected by the officer, by the office, which exercises uh, the, the granted quasi judicial powers. Okay, otherwise, if he or she goes outside of that bounds, then the action of the officer or the office will become without jurisdiction and is null and void. Right? Again, the grant of quasi judicial powers to DAR, to the offices within the framework of agrarian reform, does not make these offices courts. Okay? They do not become courts just like courts which are under the judicial branch of the government. All right? And so, because these are not courts, but rather quasi judicial bodies, administrative bodies which exercise some form of powers that would enable him would enable the office or the body to adjudicate rights and obligations, to interpret the law, but they are not within the judicial branch of the government. And so these offices, no, administrative offices exercising quasi judicial bodies, are generally not bound by the rules of court. All right, they are not bound by the technical rules applicable to the courts, simply because they are not within the framework of the judiciary, and therefore the rules of court which apply to courts will generally not apply or not bind the administrative bodies which exercise quasi judicial powers. All right. In fact, these administrative bodies, in fact, within the framework of RA 6657, they are governed by their own rules. They are governed by the rules approved, which are specifically applicable to cases that are cognizable by these quasi judicial bodies, by these administrative bodies exercising some form of quasi judicial power. All right. And as I said, uh, even though the law grants quasi judicial powers to DAR, for this is just for purposes of delegation, for administrative, uh, uh, let's say, administration of the functions granted to it by law. All right, the the power to exercise quasi judicial powers are somehow exercised by these three offices, which are within the framework of DAR. Don't be mistaken, huh? These offices are exercising quasi judicial powers because they are within the framework of DAR, and for purposes of clarity and administration, they are called as such. They are given these names for the people, not just for the people, but also for for the workers or employees or officers within the Department of Agrarian Reform, to be able to know, to be guided as to what their functions are. All right, and so here, uh, within the framework of the DAR, of the Department of Agrarian Reform, we have the PARAD, we have the RARAD, and we have the DARAB. Okay, these offices are the ones delegated to exercise the quasi judicial functions granted to DAR by RA 6657. Now, PARAD just means Provincial Agrarian Reform Adjudicator. Okay, so PARAD. RARAD is just Regional Agrarian Reform Adjudicator, while DARAB just means DAR, the Department of Agrarian Reform Adjudication Board. All right, and for purposes of our discussion, we shall be discussing often these offices which are delegated to exercise the quasi judicial functions as vested under RA 6657. All right, and so having identified, having established the existence of quasi judicial powers under RA 6657, and likewise having identified the offices which exercise the quasi judicial powers as vested by RA 6657, we are now ready to discuss, okay, the subject of quasi judicial powers under RA 6657. If these offices have quasi judicial powers, and if quasi judicial powers are limited, no, as vested by law for purposes of this discussion, then we need to know what is included in the power, in that quasi judicial power. What are the matters which may be subject of the exercise, of the valid exercise of quasi judicial powers within the framework of RA 6657? Now, we can answer that by first identifying what is an agrarian dispute. All right? what is an agrarian dispute? Now, the law, RA 6657, does not give us an all-encompassing meaning of agrarian dispute. Okay? Rather, the law defines agrarian dispute by example, okay, or by identifying the kinds of cases that may become or that may come into the notion of agrarian dispute. Okay? In fact, the law RA 6657 points to three different groups of cases which may come within the purview of agrarian dispute. All right, uh, and these are first, these are controversies involving tenurial arrangements over lands devoted to agriculture. We can call this tenurial arrangements disputes, all right, or controversies. Okay, and second group would be controversies relating to compensation of lands acquired under RA 6657. We can call this just compensation controversies or just compensation disputes. All right, and we have in a separate provision, we have for purposes of agrarian dispute, we have criminal offenses that relate to matters provided under RA 6657 or RA under Carl as amended. Okay, so we have these three na mga kinds, na mga groups of cases which fall under the purview of agrarian dispute. Now, it's important that we try to discuss them separately because the procedure, the rules on judicial review will vary. Okay, somehow vary, uh, and so we shall discuss them one by one, okay? Starting with the controversies involving tenurial arrangements over lands devoted to agriculture or tenurial arrangements disputes. All right. Now, for tenurial arrangement disputes, we have the following kaning general na procedure. All right. Uh, when we say tenurial arrangements disputes, we refer to such controversies or disputes relating to the tenure of a farmer, of a beneficiary, of a of an agricultural lessee, or a share tenant. Okay, even though it was already a share tenancy, was already converted, but in order for it to become uh, uh, all encompassing, no, tenurial arrangements should mean the controversies relating to the tenure of farmers, farm workers, tenure uh, of agricultural lessees, no, of such other farmers which who are considered as beneficiaries under RA 6657. These may fall under this group of controversies involving tenurial arrangements over lands devoted to agriculture. Now, if a controversy or a dispute, right, will fall under this controversy, this group of controversies, then that controversy will have to be governed by the procedure for this. Okay, will have to be governed by the procedure for tenurial arrangements. Right, and it all starts the procedure for tenurial arrangement controversies starts with the Barangay Agrarian Reform Committee. Okay? starts with the Barangay Agrarian Reform Committee, or BARC. Okay, why? Because in the BARC, in the Barangay Agrarian Reform Committee, prior mediation and conciliation, okay, as certified by the BARC, will be conducted. Okay, because these are tenurial arrangements, these are controversies which relate to the tenure of farm workers, of agricultural lessees, etc. Then the rules, no, the Darab rules, the law uh, presupposes that this may be settled by I mean, this may be amicably settled, okay, even before going to, to I mean, going into a full blown case, no, within the framework of RA 6657. And so with the possibility that this may be amicably settled outside the full blown case, all right, there is a requirement that before a tenurial arrangement controversy will reach, all right, the quasi judicial bodies under RA 6657, there must be a prior mediation and conciliation effort. Okay, and within the framework of the Darab rules, the BARC, right, and the law, of course, no, the BARC of the Barangay Agrarian Reform Committee will have the function to facilitate this prior mediation and conciliation. All right, it's also the BARC which will certify the conduct of the prior mediation and conciliation, and this certification will be a requirement, okay, when a person files a case to a quasi judicial body within the framework of RA 6657, because under the rules, specifically Rule 3, Section 1 of the 2009 Darab rules, prior mediation and conciliation with the BARC is a condition precedent. Okay, it's a condition precedent in the filing of a formal case with the quasi judicial bodies within the framework of RA 6657 or of the DAR. Right? Without this prior mediation and conciliation, a case before the quasi judicial bodies under the DAR will be dismissible. Dismissible for having failed to comply with the conditions precedent for the filing of the case. All right. Very important, therefore, to note that as future lawyers and as future lawyers who will have clients who may have agrarian disputes and specifically tenurial arrangement controversies or disputes, it's important that first you advise the client to undergo the prior mediation and conciliation with the BARC, no? Because the principle here is that the prior mediation and conciliation with the BARC is a condition precedent. Okay, uh, but of course, this is the uh, general rule. Right? This is the general rule, while certain exceptions apply. Right? Now, since we are talking about tenurial arrangements here, the other exception which is found also in the rules, I omitted, no, which is the exception is that uh, uh, when the dispute is about just compensation of the landowners. Now, specifically, it's not here because just compensation disputes are governed by another set of procedure which does not require a prior conciliation and mediation. All right, and so it's here actually in the codals. It's there, just compensation disputes. But for purposes of this discussion, I only identified these three disputes whereby they may in I mean these three scenarios or exceptions may include or involve uh, tenurial relation controversy, but because they fall under these exceptions, then a prior mediation and conciliation is not required, no, to be undertaken before the DAR. All right, and so for the first exception, and this you shall find also in the uh, Katarungan Pambansa law, uh, in that law which requires as a condition precedent to filing cases as a general rule in courts, requires dapat na ay uh, uh, but there in the barangay, no, uh, some sort of mediation and conciliation uh, uh, proceeding, okay, which you will be discussing in your local government code class, perhaps in your second semester, or perhaps you're taking it right now, right? And this exception is somehow similar to an exception to that law, which is when one of the parties is a corporation. Okay, when one of the parties is a corporation, within the rules, DARAB rules, a prior mediation or conciliation is not required, even if the controversy may amount to a tenurial arrangement controversy. All right, perhaps we can say, uh, if for example Hacienda Luisita Incorporated, it's a corporation, and then there's a dispute with regard to the tenure of some or many of its farmers stockholders, then in that sense it may be considered as a tenurial arrangement controversy, but because one of the parties is a corporation, in this case Hacienda Luisita Incorporated, then it is not anymore required for the plaintiffs or complainants to resort to uh, prior mediation and conciliation with the barangay, okay, agrarian reform committee, right? That's first exception. Now, second exception is when the secretary of the DAR, okay, directly refers a case to the DARAB. All right. In this case, a prior mediation and conciliation is not anymore required because it will not undergo the full process as provided for in the rules, which will have to start on the first level and then the first level and then go to DARAB. All right. In this case, the matter is referred directly by the secretary of DAR to the DARAB. Okay, in which case it's already cognizable by DARAB, and therefore per the 2009 DARAB rules, there is no more need. There's no more need to um, to resort to prior mediation and conciliation before the park, right? And the last uh, exception to the general requirement of prior mediation and conciliation is the non-existence of the bark, no? Which happens, uh, which is possible when it's somehow a remote location, a remote barangay where the barangay is undermanned, for example, or if uh, the the positions are not filled, there are no persons who are appointed to that barangay committee, in which case there's non-existence, okay, and the non-existence of the bark should not impede the cause of action, especially if the cause of action is legitimate, to be filed with the proper quasi-judicial bodies within RA 6657. All right. And also, there are also instances where there may be a bark. Okay, there may be a bark constituted, but for one reason or another, the bark fails to convene. No, this is also a this is a necessity. No? This exception is a necessity because uh, if the if the bark, no, needs to, I mean, if a person needs to undergo mediation and conciliation, but the Barangay Agrarian Reform Committee, refuses or fails to convene, then the cause of action of a farm worker, of an agricultural lessee, will be held hostage by the failure, perhaps, or refusal of the bark to convene. That's why, under this exception, even though there is a bark, and even though it is a tenurial arrangement controversy, but if the bark fails to convene, then the party having cause of action is not anymore required, all right, to undergo mandatory conciliation and uh, mediation before the bark. Again, I repeat, no, the general rule when it comes to tenurial arrangement controversies, there must be prior mediation and conciliation with the bark. All right? But there are exceptions to this, even though the case is considered as a tenurial arrangement. All right? Uh, in which case, the exceptions are one of the parties is a corporation, number one. Number two, if the secretary of DAR directly refers a case to the DARAB, in which case there's no more need for prior mediation and conciliation. And lastly, if the bark does not exist in the locality, or even if it does exist, it fails to convene, and therefore the requirement for prior mediation and conciliation is dispensed with. All right, that's for the exceptions. Okay, now if you can observe, no, beside the Barangay Agrarian Reform Committee is the Presidential Agrarian Reform Committee, or the PARC. All right, but as you can see, it's not an arrow going from BARC to the Presidential Agrarian Reform Committee, right? In fact, it's the PARC, no, going to the Provincial Agrarian Reform adjudicator. Now, why is this? Why is the Presidential Agrarian Reform Committee here beside the BARC? Huh? Will the BARC, no, will the results of the BARC prior mediation conciliation be appealable to the Presidential Agrarian Reform Committee? Or is the Presidential Agrarian Reform Committee an alternative venue for the Barangay Agrarian Reform Committee? Right? Uh, no. Within the framework of RA 6657, the park, yes, the Presidential Agrarian Reform Committee is not a substitute to the BARC. Okay? As a general rule, as I've said, no, when it comes to tenurial arrangement controversies, the requirement is that there must be prior mediation and conciliation. Okay? And the conduct of the prior mediation and conciliation is best evidenced by the certification by the BARC. By the certification by the BARC that indeed a prior mediation and conciliation happened, but the parties failed to amicably settle the case, and therefore this will have to be forwarded to the quasi-judicial bodies under DAR. Okay, but there are cases, however, where even though the conciliation mediation happened, but the BARC fails or failed to issue the certification. In which case, diba, the condition precedent naman is the conduct of prior mediation and conciliation, right? Uh, but the courts, I mean, but the PARAD, the Provincial Agrarian Reform Adjudicator, in order for that office to be satisfied that indeed a prior mediation conciliation happened, will have to ask for the BARC certification. No, without the BARC certification, it cannot reasonably conclude that indeed the condition precedent was fulfilled. And so, in cases where the BARC certification are not released or not issued, but indeed the prior mediation and conciliation happened, then the park can step in, all right, and issue the certification itself, okay, without waiting for the park, okay. But the failure to issue the certification will have to span for a period of 30 days from the time the alleged conciliation or mediation happened. No? Because and so therefore the rule should be the BARC certification should be released and issued within a period of 30 days from the time the prior mediation and conciliation proceedings happened. If the BARC fails to issue the, the certification within that period, then the PARC, the Presidential Agrarian Reform Committee, can issue the certification uh, itself, okay, without waiting for the BARC. This is important because in some cases, perhaps, in some cases, the cause of action of a farmer or of an agrarian of an agricultural lessee may be unduly suppressed, may be unduly impeded by the mere failure, okay, failure or let's say refusal of the BARC to issue the certification, because the case will not be accepted by the PARAD. The case will not be accepted by the the uh, the Provincial Agrarian Reform Adjudicator without this certification again, because this is the best evidence for the conduct that indeed a mandatory conciliation and mediation proceeding had been conducted. Okay, and so in order to address those kinds of scenarios, okay, in order for the cause of action of the farmer or agricultural lessee to be not held hostage by the failure or perhaps refusal of the park to issue the certification, then the park Presidential Agrarian Reform Committee will come in to issue the certification itself. Okay, uh, in favor of the person, in favor of the person who has a cause of action. Okay, the therefore, okay, the bark does not go to park. I mean, the person who has undergone the mandatory conciliation and mediation program does not go to park for purposes of appeal. All right, that's in no way an appeal. That's just a mechanism in order to address that possibility. In some cases, remote, but in most cases, perhaps a very great chance of happening, no? Where the BARC certification is withheld, where the BARC certification is not issued within the period of 30 days after the conduct of the mandatory conciliation and mediation proceedings, in which case the park will step in and issue the certification, okay, needed in order for the PARAD in order for the provincial agrarian reform adjudicator to be satisfied that indeed a mandate, or the condition precedent, okay, had been complied with. Right? And so we go to the provincial agrarian reform adjudicator, or the PARAD. Okay? The provincial agrarian reform adjudicator, insofar as tenurial arrangement controversies are concerned, okay, has exclusive and original jurisdiction over agrarian disputes. As a general rule, exclusive original jurisdiction siya over agrarian disputes. Of course, even though this is the case, the Secretary of DAR is vested with the power to directly endorse a case to the DARAB for resolution, in which case it will not go through PARAD anymore. All right, it will have to go directly to DARAB. But as a general rule, PARAD, the Provincial Agrarian Reform Adjudicator, will have exclusive original jurisdiction over agrarian disputes. Okay? But of course, the jurisdiction of the PARAD is with express boundaries. No? Even though the matter may still be an agrarian reform related matter, but if this matter is expressly uh, uh, outside the boundaries of the jurisdiction of PARAD, then the PARAD will have no power, will have no jurisdiction to touch or to adjudicate on that matter. Now, let's go first to this express boundaries of jurisdiction. Okay, uh, there are, like, these are just some of the several na mga items or mga matters which may arise from an agrarian dispute, which may be an issue attached to a tenurial arrangement controversy, but because they are expressly excluded, the PARAD will have no jurisdiction whatsoever to adjudicate on these matters. No? Firstly, adjudication of ownership. Adjudication of ownership, that's a function of the courts, right? When you file your action publiciana, your action re investigatoria, your unlawful detainer case, enforceable entry cases, these are adjudication of possession, ang mga unlawful possession, unlawful detainer, enforceable entry. But action publiciana, action reivindicatoria, right? Adjudication of ownership, they are there. They are cognizable by the regular courts within the jurisdiction of the courts, and therefore they are outside of the jurisdiction of the PARAD, even though that matter arises from an agrarian dispute. Right? Of course, adjudication of right of way, again, does not belong to the jurisdiction of the PARAD. It belongs to the jurisdiction of the regular courts. Okay? Retention and exemption issues, not within the framework of the quasi-judicial bodies, because retention and exemption are on the matter of implementation of the law, which is which the jurisdiction in this matter is vested in the implementation part of the DAR. Okay, again, reclassification and conversion, it's also a matter of implementation, and therefore not within the quasi-judicial powers of the DAR, and same also with identification and selection of beneficiaries. These matters, even though they arise from a tenurial arrangement controversy, because these matters are expressly excluded from the jurisdiction of the parad, then the parad will have no jurisdiction whatsoever in ruling, in adjudicating on these matters. All right. And so we go to the matter of exclusive and original jurisdiction of uh, of the parad. Okay, what's the effect? What are the effects of it being an exclusive and original jurisdiction? Okay, original jurisdiction means that cases involving tenurial arrangement controversies, as a rule, must be filed first in the parad. Okay, original na siya. Okay, original na siya. And exclusive means that no other court or tribunal, as a rule, shall take cognizance of agrarian dispute. Again, because the secretary has the power to bypass, has the power to immediately endorse the case to the darab, then this is a matter of general rule. All right. Uh, no other court or tribunal shall take cognizance of agrarian dispute. All right. Now, what's the effect of this one? What's the effect of it being uh, original and exclusive? All right. Specifically exclusive. All right. Now, here we discuss one aspect of the procedure for when an agrarian dispute is filed in court. All right. Uh, Here in this illustration, uh, we have an ejectment case. All right, we have an ejectment case filed with the MTC, right, with the Municipal Trial Court. Okay, ejectment case, perhaps a forcible entry or unlawful detainer case, no, filed against a person with the MTC. So you know, MTC ang jurisdiction for unlawful detainer cases, ejectment cases. Okay, but then the person or defendant in that ejectment case filed in the MTC said that, oh, I am being ejected, but I'm an agricultural lessee. Okay, we have an agricultural lease with the owner, with the complainant, and so here it involves a matter of the tenure of an agricultural lessee. And as we have established a while ago, tenurial arrangement controversies may involve, no, the tenure of such farmers, agricultural lessees over the agricultural land. In which case, here the defendant is raising an agrarian dispute, okay, as a defense. Now here, what happens when the defendant, who is an alleged agricultural lessee, raises this fact, raises an agrarian dispute? Of course, it will not move forward as all the other normal na mga ejectment cases that are filed with the MTC. Alright? Because the defendant is raising an agrarian dispute, then the MTC has the duty to refer the matter. No? The MTC has the duty to refer the matter to the Department of Agrarian Reform, because here, no, the defendant raises an agrarian dispute. And so the MTC has to refer the matter or the case to the DAR for determination of what? Determination of what? Determination of the existence of agrarian dispute. Okay? Because after the DAR receives the referral, the DAR will have to evaluate, will have to determine whether an agrarian dispute exists or does not exist. Okay? If the DAR determines that an agrarian dispute does not exist, okay, and then the case will have to go back to the courts, and the case will proceed as a normal uh, case, in this case normal ejectment case. Okay, because the DAR itself certified that no, there's no agrarian dispute here. It's a normal ejectment case. uh, Go back to court and the court will dispose of the case accordingly. Okay, but if the DAR if the DAR determines that there is an agrarian dispute, then the matter will have to be taken cognizance of by the PARAD. The matter will have to be forwarded to the Provincial Agrarian Reform Adjudicator. Because it is a case with agrarian dispute, then insofar as that agrarian dispute is concerned, PARAD has original and exclusive jurisdiction. Okay? Now, you might say, oh, the DAR here is very powerful. The DAR here is given the power to decide which forum will a case be decided. Okay, isn't that somehow unfair given that uh, the determination may be subject of, let's say, corruption, let's say influence from other persons, in which case don't we have some remedies against the determination of the DAR? We do. Okay, actually, under the rules, the determination of the DAR as to the existence of agrarian dispute or non-existence of agrarian dispute is appealable. Okay, it's appealable. Okay, so where do we appeal? Uh, where do we appeal the determination of the DAR? Now, the appeal will have to depend on who or what court or office referred the case to the DAR. Because if the MTC referred the matter to the DAR, okay, such as in the case in our illustration, if it was the MTC which referred the matter to the DAR, then the appeal, okay, over the determination by the DAR will have to be with the RTC. You appeal to the RTC. Okay? If the MTC or the prosecutor, you have to appeal to the RTC. If the RTC referred the matter to the DAR, then the person wanting to appeal the determination of the DAR will have to go to the Court of Appeals to question that determination. Again, if the MTC or the prosecutor for that matter, with regard to criminal actions or violations, as we shall discuss later on, okay, the appeal should be to the RTC, while if it's the RTC which referred the matter to the DAR, then the appeal to the determination of the DAR should be to the Court of Appeals. All right? Okay. And so that's the matter for PARAD, for the Provincial Agrarian Reform Adjudicator. But then again, you see an office here beside the Provincial Agrarian Reform Adjudicator. No? And as you shall see, as you can see, it's not an arrow from Provincial Agrarian Reform Adjudicator to the Regional Agrarian Reform Adjudicator. No? Uh, it's not therefore a relationship of appeal, right? From the provincial adjudicator to the regional adjudicator. So what then is the role of the regional adjudicator here, and what is its relationship with the PARAD here with regard to the exercise of powers? All right. Now, the jurisdiction of PARAD, all right, is likewise original. Okay? The jurisdiction of PARAD is likewise original, but it's limited. All right? Its original jurisdiction Therefore, it is therefore of original jurisdiction, and therefore it does not exist for purposes of appellate jurisdiction over the decisions of the parad, right? In fact, the rarad is there with limited original quasi judicial powers, no? Uh, but then it's higher than parad for purposes of administration, no? For administrative uh, matters, but not certainly not for appeal. Okay, there here therefore the rarad's jurisdiction to hear cases are limited on these three matters. Now, first is when the Rarad, okay, the Rarad may hear and decide cases, okay, when the Parad, when the provincial adjudicator cannot hear the case due to disqualification, inhibition, or absence. Okay? In which case, because the provincial adjudicator is in is unable to hear the case, then the regional adjudicator will have to come in. Okay? That's the first instance where the RARAD has jurisdiction. Okay? The second instance in which the jurisdiction in which RARAD, the regional adjudicator, has jurisdiction is when the case involves matters of such complexity and sensitivity that the decision would constitute an important precedent affecting regional interest. In which case, the parad will have to forward the matter to the regional adjudicator if the case uh, belongs to this description. No? The case involves matters of such complexity and sensitivity that the decision would constitute an important precedent affecting regional interest. In which case, it's not anymore the provincial adjudicator, no, who shall, by the way, forward the case to the regional adjudicator. Now, it's the regional adjudicator who shall have jurisdiction to resolve the matter. All right? And also in such cases, no, for the third kaning, group of cases in which the regional adjudicator has jurisdiction, no, in some cases, the DARAB will assign the hearing, the conduct of hearing on applications for TRO, for writ of preliminary injunction against the parad, against the decision of the provincial adjudicator to the regional adjudicator. Okay? In which case, if the DARAB assigns the conduct of hearing to the RARAD, then the RARAD will have jurisdiction to hear the application for TRO, application for writ of preliminary injunction. But ultimately, it is the DARAB which will issue the writ of preliminary injunction or TRO. No? The jurisdiction of the regional adjudicator in such a case is merely to conduct the hearing and then recommend to the DARAB, no, after its findings, recommend to the DARAB the proper action. But it is the DARAB which will ultimately issue the writ of injunction or the TRO if warranted. Alright? And also, the regional adjudicator has administrative functions over the PARAD, such as the audit of cases, the monitoring of the caseload, monitoring of the cases, the movements of cases with the PARAD. Alright? But in no way does the RARAD, does the regional adjudicator exercise appellate powers over the PARAD. Alright? Because what has because the office which has appellate powers over both the provincial adjudicator and the regional adjudicator is the DARAB, or the Department of Agrarian Reform Adjudication Board. Okay, now unlike RARAD, okay, DARAB has appellate jurisdiction over PARAD. In fact, it also has appellate jurisdiction over RARAD, over the regional adjudicator. Alright? And the DARAB's decision, because the DARAB is a quasi-judicial agency, okay, the decision of the DARAB is appealable to the Court of Appeals. Alright? So you can see here, from the BARC to the PARAD, or in some cases RARAD, and then ultimately to DARAB, okay, the decision will be appealable to the Court of Appeals via Rule 43. And you shall learn later on in your appellate law practice, or in civil law, civil procedure, right? That this Rule 43 is specifically provided for appeals against decisions of quasi-judicial bodies, right? Enumerated there, okay? And so, because the DARAB is a quasi-judicial body, and there's no more above it, then the decision of the DARAB will have to be appealed to the Court of Appeals via Rule 43, and whatever decision of the Court of Appeals in this case will be appealable further, and lastly, to the Supreme Court via Rule 45. Alright? Okay? And so, we move on to the matter of the power to issue a TRO, the power to issue a writ of preliminary injunction against the DARAB, against the PARAD, against the RARAD. Okay? As you can see here, let's just focus here first in this portion of the screen. So you can see here, the DARAB, okay, has power to enjoin the PARAD. Okay? The DARAB also has the power to enjoin the RARAD. Okay? The DARAB can issue a writ of injunction against the provincial adjudicator. The DARAB also can issue a TRO or a writ of preliminary injunction against the regional adjudicator. Okay? Which is understandable because they belong to the framework of RA 6657, diba? And for purposes of this supervision here, the DARAB has the power to enjoin them, to tell them to not do an act, to stop doing an act. Okay? But as you can see, also, we have red lines here, coming from the Supreme Court. Because under the law, there is a prohibition, okay, on the courts to issue writs of preliminary injunction or TRO in agrarian disputes. No? This prohibition is represented by this line here. No? The courts, normally, Court of Appeals or the regional trial court, they have jurisdiction to issue writ of preliminary injunction even against government offices, even against mga offices in the executive branch. But because the law, RA 6657, imposes a prohibition against that power, okay, then the lower courts, Court of Appeals or regional trial court, will have no power to enjoin even the PARAD, the RARAD, especially the DARAB. Alright? Because, the jurisdiction of the Court of Appeals and the regional trial court are provided for by law. And therefore, their jurisdiction, which is provided for by law, may be modified by another law. Right? But the jurisdiction of the Supreme Court, as you know, the jurisdiction of the Supreme Court is not provided for by law. not just by law, but by the Constitution. In which case, a law prohibiting the issuance of a TRO will not apply to the Supreme Court. Okay? In fact, the Supreme Court is the recognized only exception to this prohibition. In this case, the Supreme Court can overcome the prohibition, and the Supreme Court may validly issue a writ of preliminary injunction against the DARAB, against the PARAD, or against the RARAD. Okay? And this is perfectly within the powers of the Supreme Court, as the Supreme Court is a recognized exception. Again, we repeat, no, the power to enjoin the PARAD and the RARAD should at first instance belong to the DARAB. Okay? And there is a prohibition against the courts to issue a writ of preliminary injunction or TRO against PARAD, RARAD, or DARAB, no? except for the Supreme Court, because the Supreme Court is a recognized exception. The Supreme Court has jurisdiction, the power to enjoin DARAB, to enjoin the provincial adjudicator or the regional adjudicator if the Supreme Court finds it warranted. All right? Okay. Okay. Now, that's it for the discussion on tenurial arrangement controversies and rules and procedure with regard to tenurial arrangement controversies. No? In the next video, we will discuss the disputes. The procedure relating to disputes involving just compensation, which, by the way, is the second type of groups of cases falling under agrarian dispute. Okay, see you there.